That brings us to item number 4, AB 2667. We do have a motion and a second. Mr. Thurman, proceed.
Thank you, Mr. Chair and members of the committee. It's an honor to be before you to present AB 2667. This bill is about protecting legal rights. As you know, our Californians are often, without knowing so, sign away their rights in what we would call forced arbitration. We want to change this practice because we know that this lends itself to discrimination that can happen in housing in regards to sexual orientation or disability. We think that this bill builds on our body of laws that says we all have the right to have our day in court and that we should not unknowingly give those rights away. This bill builds on the tradition of the Unrest Civil Rights Act that says we protect our civil rights against discrimination. This bill prohibits requiring someone to waive their right as a condition of entering into a contract. It prohibits refusing someone's services if they were pushed into forced arbitration. And it requires that if arbitration does take place, that it be voluntary and that there be proof that that arbitration was voluntary. I want to be clear, I am not opposed to arbitration. I think it is an excellent tool for helping us to resolve many of the disputes that we have. But recognizing that people may not be aware of what they are signing away, we think that arbitration should always be voluntary and never forced. And we want to always do all that we can to protect against discrimination for the rights of our Californians. And with that, I would respectfully ask for this committee's aye vote. I'm pleased to introduce our witness, Elise Sanguinetti, who is the president of the Consumer Attorneys of California and is a great attorney practicing in the city in my district.
Thank you. First witness, please.
Yes, good morning. Thank you again for having me speak in front of you. My name is Elise Sanguinetti. I'm the president of the Consumer Attorneys of California, and I'm here in support of AB 2667. The Consumer Attorneys are a proud co-sponsor of this bill with the NAACP. AB 2667 ensures that all persons have the benefit of the rights, penalties, remedies, forums, and procedures established under California's Unrest Civil Rights Act. I know from prior experiences in front of this committee, I want to address some issues that I can anticipate that might come up from questions from this committee. First of all, I want to make sure that the committee understands that in 2014, Governor Brown signed into law AB 2617, which was a Weber bill, which limits but does not prohibit certain contractual waivers of rights under California's statutory scheme designed to protect individuals from hate crimes. This bill, 2667, is very, very similar in framework to a bill that was signed by the governor. It does not prohibit certain contractual waivers. It limits but does not prohibit certain contractual waivers of rights under the California's Under Acts. I want to remind the committee of recent media attention that has occurred, including the three-part series, the New York Times series, which highlighted some very significant problems with forced arbitration. As I know that you've heard before, there is little, if any, regulation, oversight, or legal accountability in private arbitration. Arbitrators are not required to be trained in the law. They are not required to render a decision consistent with the evidence that is presented, and they are not even required to apply the law in making their decisions. There's no requirement that discovery be allowed, that the rules of evidence be followed, or that a written opinion be issued. Arbitration awards are binding decisions that are legally enforceable, yet they are rarely allowed to be reviewable by a court. In addition, the proceedings are private, not public, which we should be most concerned about in an UNRRA civil rights violation situation. I'm going to cut through some of these to move things along because I know you all have had a long day. But AB 2667 applies to, it's very limited application, and it's not attacking arbitration as a whole. It's only saying, and it will not run afoul of the FAA, the Federal Arbitration Act, because it does not stop parties from going to arbitration. It does not increase the costs of arbitration. It does not reduce the efficiencies of arbitration or dictate the rules of an arbitration proceeding. Instead, it says that California residents must voluntarily make a waiver of their rights under the UNRRA Civil Rights Act. The waiver cannot be required as a condition of entering into a contract for goods and services. AB 2667 would provide that it is the policy of the state of California to ensure that all persons have the full benefit of the rights, penalties, remedies, forms, and procedures established under the UNRRA Act. As I said before, it's modeled after existing law that was signed by the governor, and accordingly, I respectfully ask for an A vote.
Thank you. Next witness, please.
Good morning, Mr. Chair and committee members. Joe Michael for Equality California. We're happy to support this bill, and just briefly, I'll explain what the connection is to the lesbian, gay, bisexual, and transgender community. As the author mentioned, this issue does come up in the context of sexual orientation and gender identity. The UNRRA Civil Rights Act protects the LGBT community and is a significant source of those protections. And specifically, recently, there was an incident of sexual orientation discrimination involving a driver for a ride service who shouted obscenities at a passenger and kicked him out of the vehicle after the man shared a kiss with another passenger. So that's just an example. There have been similar incidents reported involving other drivers in similar sorts of employment, discriminating against passengers with disabilities. So this is an issue that significantly affects the LGBT community and other marginalized communities, and we think it's important to address it in this way that is narrowly tailored. And we also wanted to note that we supported Assemblymember Weber's bill from last year and think that this is in line with that, and respectfully urge the committee's support today. Thank you.
Thank you. Anyone else in supports?
Good afternoon. Aaron Lewis for the Consumer Federation of California, in strong support. Thank you.
Thank you.
Good afternoon, Mr. Chair and members. Kevin Baker for the American Civil Liberties Union of California. I believe that when you hear the opposition testify in a minute or two, you will hear about their claim about the many wonderful attributes about mandatory arbitration. If that's so, I don't think it is, but if it's so, I would suggest that we be asking, if it's so wonderful, what's wrong with voluntary?
Thank you. Anyone else in support? All right, seeing none, opposition?
Mr. Chair and committee members, Jennifer Brewer on behalf of the California Chamber of Commerce, and we are opposed to AB 2667. Similar to our discussion last year with Mr. Chair's bill regarding military members, it has nothing to do with regards to whether or not we disagree with civil rights. Of course, we are totally in support of that and want to make sure that those are upheld. It all has to do with regards to the premise that arbitration is somehow bad. And again, talking about the preemption issue as well. So those are kind of the things I want to highlight. This bill is no different than with regards to AB 465 that was vetoed by the governor last year. It's just witching out what claims we're talking about. In the AB 465, we were talking about as a condition of an employment contract, you couldn't have an agreement to limit your ability to bring labor code violations to court. This is saying as a condition of a contract for consumers, you can have an agreement to waive your rights to bring civil rights violations to court. So it's just changing out the labor code or the labor code section for the civil code section and the consumer contract for the employment contract. But other than that, the language is pretty much identical. So we think it's very similar to AB 465 that the governor actually vetoed last year. And one of the bases that he vetoed it on was because he was concerned that that provision limiting your ability to have as a provision of a contract the requirement to arbitrate was preempted by federal law under the Federal Arbitration Act. I'm not going to go into great detail again on the preemption argument that we talked about last week, but I do want to highlight an issue that was raised in the analysis on the DirecTV and Brugia case. I probably just mispronounced that. That was just issued late in 2015 from the United States Supreme Court, which was one of the cases that the governor actually referenced in his veto message at AB 465, wanting to know how that case was going to come out. The analysis suggests that they just reaffirmed the AT&T Concepcion case that said you can have class action waivers as a part of your arbitration agreement. I disagree with that analysis. What the United States Supreme Court was basically critical of the California courts and said, California, you cannot identify an invalid statement of law to target arbitration provisions and invalidate those arbitration provisions. We held that the Discover case, I'm talking the Supreme Court held that the Cyberbank case was an invalid statement of law that said class action waivers were invalid. We said that in AT&T Concepcion, and then California, you went back and applied that invalid statement of law to target and discriminate against arbitration agreements. You cannot do that, California courts. And so we are reaffirming again that you can't target and discriminate against arbitration provisions. We believe that this bill targets against arbitration provisions because there are a lot of other provisions that you can agree to as a condition of a consumer contract that would not be invalidated under the new definition of unconscionability that is only applicable to arbitration agreements. And just for a moment, I want to talk about these horrible arbitration agreements that the proponents keep talking about. The AT&T Concepcion agreement was a consumer arbitration agreement. It was for the purchase of a cell phone, and the proponent was alleging that they didn't get their free phone as alleged because they were charged approximately $34 in state sales tax. And they took that case and they tried to go to litigation with a class action. The arbitration agreement provided for the following. It allowed the plaintiff, the consumer, to identify where they wanted to or how they wanted to have the arbitration conducted, whatever was most convenient for the consumer, by telephone, by written submission, or to actually have an in-person arbitration. It was in the county where the consumer was billed for the phone. It provided that if they went to arbitration, and I'm almost finished, 1 second. If they went to arbitration and they didn't get a higher amount than what the company offered for settlement, they would get an additional $7,500 as well as 2 times the reasonable attorney's fees. That's much better than any consumer is likely going to do in court in a class action where they get a minimal amount and the attorneys recover a lot in attorney's fees.
Thank you.
Thank you.
Next witness, please.
Mr. Chair and members, Chris McKaylee on behalf of the Civil Justice Association. First, I want to acknowledge the time that the author spent with us so that we could express our concerns with his legislation. Our opposition is based not at all on the benefits of the Unruh Civil Rights Act. We have had a consistent position in opposition to AB 2617, Ms. Weber's bill on hate crimes, AB 465, your measure last week, Mr. Chairman. We see tremendous benefit in arbitration. I think, as the U.S. Supreme Court said in the Concepcion case, it provides lower costs, greater efficiency and speed, and I would add greater predictability for both sides. Consumers benefit just like businesses do. Consumers pay less, businesses pay less in arbitration. Speed to resolution. The average arbitration in California is roughly 11 months from start to finish. The average civil case, roughly 31 months. There's been a lot of criticism waged or lodged against arbitration and arbitrators. I would cite to you the mandatory disclosures, the Judicial Council rules since 2002, the Code of Civil Procedure provisions. Repeat players has been a critical component of the opposition. On March 1, the Senate Judiciary Committee held about a 4-hour hearing and I think discussed ad nauseum the issues of preemption and other items. And it was interesting that the president of JAMS, one of the 2 major providers, actually said that the repeat player is the plaintiff's lawyer as opposed to the defendant. And what he indicated is that the marketplace will take care of any repeat player problem. In other words, both sides, plaintiffs and defendants, have the ability to determine and choose an arbitrator. If somebody consistently decides for one side or the other, they're not going to be chosen. I would pose this question: how do consumers benefit if this bill is enacted? I think there isn't any benefit, because what's going to happen is that they're going to go to an overburdened and overworked court system that's going to increase their costs, the time to litigation. And how do consumers ultimately benefit by class actions? I cited last week on the chair's bill a number of instances in which class action attorneys benefited tremendously from class actions and those settlements and litigation, but not the individual plaintiffs, the ones who get the $5 coupon, for example. And finally, I would note that I have yet to see an attorney fee agreement that doesn't include an arbitration agreement signed at the time that the plaintiff or their client signs that representation agreement. Thank you.
Thank you. Anyone else opposed?
Good afternoon. Good afternoon, Chair and members. Matthew Allen, Western Growers Association. We're also opposed.
Thank you. Anyone else in opposition? All right, seeing none, I'll bring it back to the committee. Questions, comments? We have certainly been through the arbitration, and I agree with you, Mr. Thurman, that one of the issues is that in a closed system, there are other rights that ultimately become a challenge. And I think you're right in raising the issue about civil rights violations and making sure that anyone who is subject to a civilized violation, is subject to discrimination, has access to the courts, has access to an open venue. And that's why I'm recommending a support, and the recommended motion is do pass. We do have a motion in a second. Any other comments, questions? All right. Seeing none, Mr. Thurman, you may close.
Thank you, Mr. Chair and members of the committee. As we have said, that we have no objection to arbitration when the parties have chosen that. We think that arbitration should be voluntary and that people shouldn't waive their rights without knowing it, so that should they need the opportunity to have a remedy to an injury that they've experienced, they do have. So we'd respectfully ask for your aye vote.
Thank you. Call the roll, please.
Stone?
Aye.
Stone, aye. Wagner? No. Wagner, no. Alejo? Chow? Chow, aye. Chu? Chu, aye. Gallagher? No. Gallagher, no. Garcia? Holden? Garcia, aye. Holden? Mainshine? Ting? Ting, aye.
Needs one more vote, so we'll put that bill on call.
Thank you.
Thank you. That brings us to item number 3, AB 2362, Chu. Mr. Ting, you're going to present? Oh, Holden's going to present that? Oh, we have two items, 2362, Mr. Chu's bill. Are you going to present that bill? Yes. Okay. That's what I was trying to get to. Yes. Yes. And Mr. Chu will present Mr. Chu's bill right after this one. This is our item number 3.
Perfect. Thank you, Mr.
Please.
Chairman. Members, unfortunately, Assemblymember Chu Kansan Chu had to attend a conflicting event in his home district, couldn't be present. In his absence, I accept the committee's recommended amendments. I want to thank the staff for their work on the issue. AB 2362 would require a homeowners association to provide notification to owners and tenants in a common interest development if the association applies pesticides without a licensed pest control operator. Last year, the legislature approved and Governor Brown signed into law Senate Bill 328 by Senator Hueso, which added guidelines that landlords and property owners must follow to properly notify their tenants if pesticides are applied by a non-licensed individual. With me today is Brandon Kitagawa with Regional Asthma Management and Prevention, and
it's just me today.
Just you. Thank you. And respectfully ask for a vote.
Thank you. And the bill does enjoy support. So your first witness, please.
Good afternoon. My name is Brandon Kitagawa with Regional Asthma Management and Prevention. We've worked with lots of partners around the state for the last 3 years on healthy housing related issues, including issues around pesticides, pests and pesticides. And this year, this bill is really trying to clean up an issue that we identified actually in this committee last year with Senator Hueso's bill, that the bill that we were working on last year, we recognized pretty late that it wasn't going to apply in the context of homeowner associations, and with very limited time to try to figure that out, we decided to not include that in last year's bill and try to see if we can find a way to make the same policy work in the context of an HOA this year, and that's what this bill is doing.
Thank you. Next witness, please.
Yeah, thank you, Mr. Chairman. Skip Daum on behalf of the community.
Hold on just a second. Mr. Chu, this is your bill. Go ahead, please.
Okay. Hi. All right, again, Skip Daum on behalf of the Community Associations Institute, which represents thousands of HOAs throughout California. It's a very laudable goal for the bill. The questions that we raised are reflected in the analysis on page 7, paragraph 4, dealing with how we might more efficiently notify tenants whom we don't know versus occupants, which could be a solution. And secondly, suggest amending the bill, and we've spoken to the author about possible amendments on better signage, which would be a great way to notify not only the owners and the occupants, but also passersby through the community. Thank you.
Thank you. Anyone else in support?
Jith Meganathan, Western Center on Law and Poverty, in support.
Thank you. Anyone else in support? Seeing none, is there any opposition? Seeing none, I'll bring it back to the committee for questions and comments. And you realize Mr. Ting just completely gutted and amended your bill in his presentation, so I don't. No. No further questions or comments. Mr. Chu, you may close.
Thank you very much, and thank you, Mr. Dean, for presenting this bill, and thank you, Mr. Chair. I respectfully ask for your aye vote.
Thank you. And Mr. Ting, on your behalf, did take the amendments that were in the analysis.
Yes, I understand the amendment that we're working with the opposition.
Great. Thank you. So the motion is do pass as amended. Do we still need a motion and a second? So we do have a motion and a second. Call the roll, please.
Stone.
Aye.
Stone, aye. Wagner. Aye. Wagner, aye. Alejo. Chow. Aye. Chow, aye. Chu. Chu, aye. Gallagher. Garcia. Garcia, aye. Holden. Mainshine. Ting. Aye. Ting, aye.
That bill is out.
Thank you very much.
Thank you very much. That brings us to our last item of the day, item number 7, AB 2819. Mr. David Chu.